All right, we are here with Doug Rohan of Rohan Law to talk a little bit about some breaking news. Ross Dellinger put out a report last night. It was kind of whispered about a week ago about maybe some unequal revenue sharing for Florida State and Clemson to potentially stay in the ACC. Doug, it's been a little while. We've been in the season, which has not been a kind distraction. But how you doing, man?
I'm doing great. It's kind of like I wouldn't really say Christmas morning. This is more like the beginning of Independence Day, where suddenly the alarms start beeping and the signals start coming into the SETI office. You don't really know what's going on, but clearly something is happening, and that seems to be where we are in this settlement and litigation phase.
So let's jump right into it. What is the idea here? What's the proposed deal that both sides are maybe, or all 17, 18 sides are talking about?
Well, we have a couple different threads, a couple different pieces of evidence that we can put together. The first of which was there was a planned meeting where they started talking about probably what some of the proposals might look like and how to resolve the interests of the parties to get the settlement reached and the litigation to stop. We then had a report of a 6-hour phone conference last week, which to me indicates that, you know, these types of presidents and individuals have very busy schedules. You don't carve out time for a 6-hour meeting. What you carve out time for is a meeting, and you just decide, look, we need to get this done, or at least very close to getting it done. And we're going to stick around as long as it takes to make sure it gets done. So that's a very valuable piece of the puzzle to this now leak that's coming out from anonymous sources last night to Ross Dellinger saying, look, we have the basic framework of some kind of agreement in place. Now, these are very complicated. There are a lot of moving parts, and it's very possible that just like when you're fishing and have a big fish on the line, that it wriggles off and nothing happens and we continue with the litigation. But there's at least the concept of a plan for settlement that's being generated. So it's very clear that we at least are talking and that the parties are listening. And what it appears based on the reporting is that ESPN is going to step forward and add to the bucket of money that the conference members can share. Now, that's the big difference between what FSU proposed prior to litigation starting. And so a lot of people have brought up the point that, look, FSU has always talked about being willing to stay for an unequal revenue sharing portion, but the rest of the conference members balked at it, and for reason. They want to continue to enjoy an outsized benefit to having Clemson and Florida State in the conference. But if ESPN, who's now looking at this February 1st deadline, who's looking at the chaos of the conference, who's looking at these recent disputes with Charter and DirecTV and wanting to provide some stability for the next few years, says, hey, look, it would cost us $100 million to rework these puzzle pieces into different conferences or risk losing Clemson and Florida State to the Big Ten. Let's put together a pool of money, maybe $40, $50 million, something that's a fraction of what it would cost to negotiate a new contract. And let's go ahead and put that money aside for this revenue sharing model based on viewership. Now, it is basketball and football. So Florida State, again, with an 0-4 start, that means we've got a Final Four team in basketball coming up if our tradition holds true historically. But it is important to understand this is not just for the benefit of Florida State and Clemson. So one, we don't know how much money ESPN is contributing. Two, we don't know how this is going to be split. And three, we don't know if this is going to make a practical impact on the ultimate revenue ending up in Florida State's pocket. So those questions still need to be answered. But for the people that are freaking out saying, I hate this, I don't want any agreement that doesn't get us out of the conference, just understand the math that's at play here. It doesn't add that much more time. FSU still preserves their right to go to another conference, and we don't spend $200 or $300 million for that benefit if there was a settlement. So this does to me smell like victory. This does to me smell like a win for Florida State. You just have to take a breath, realize what the objectives were, realize how this meets Florida State's objectives, and then I think you'll be a lot more satisfied with the potential agreement.
Yeah, even if let's talk about the numbers there that you just kind of mentioned for a second. Let's say that let's say it was 20, unequal revenue based on football, basketball viewership, which even with the struggles, Florida State still number one in the ACC so far this year in viewership in the conference. And so, now I don't know that you can have years of going 0-12 and that continue, but we assume that won't happen. It's hard to target exactly what a number would be because we haven't seen that. But like you said, if it was an additional, 15 million a year, 10 million a year that Florida State was able to make. 20, obviously even better, the higher you go. I don't know. You're trying to ballpark what a number would be. I guess if you think about that number and you think about, the speculation is the grant of rights would be reduced from 2036 down to 2030. And then you say, well, your $300 million settlement, over 6 more years, 5 more years, would be roughly $50 million a year, right? So the $50 million you save in the lawsuit, the 5, 10, 15, 20 that you get from the unequal revenue sharing potentially, right? If you continue to be a brand that people want to watch, which I assume you will be, it honestly could work out to be pretty even, or maybe even slightly more when you think of what $300 million over 5-6 years would be. 300 million over, through 2036 would be a little bit different, but 300 million to settle and get out by 2030. I almost feel like that would, get you pretty close to competitive financially in not only money saved, but then the new money earned.
Well, let me make one modification to your assumptions and remind people that when we were talking about a $10 million gap to Vanderbilt in the SEC, we were talking about what happens if the grant of rights extends to 2036. That gap in 2025 is really only a couple million, 4 million to 7 million, depending on which numbers you're looking at. So ESPN doesn't need to come up with crazy numbers for those numbers to offset 2025, 2026, 2027. And remember, the secondary thing is that we're not necessarily agreeing to stay in the ACC until 2030, but by getting the grant of rights reduced from 2036 to 2030, now we can have serious discussions about 2027, 2028, which was frankly the time frame that we were already talking about. Even if we announced today, we said, look, we're going to settle it. The ACC has named their alternative price. It's $250 million. We're paying that. We're out. We're still playing a 2024, 2025 ACC conference games. So 2026 is the first time we're actually out. You mean to tell me that we don't have to pay $200 or $300 million, and instead of being out in 2026, we're out in 2028? The math is fantastic.
Let me follow up on that, or play devil's advocate, or maybe a bunch of people would have this question. We're already kind of in a little bit of a rough place because of what we agreed to in 2016 and then before that. If we agree to this, does that weaken our case to get out before 2030? I know we're probably not going to sign something that says you are bound and locked, but does agreeing to that kind of hold some weight of it would be tougher for us to get out those couple years early, like you're mentioning, legally, I guess?
I think that's a fair point. You are conceding on basically your argument that you improperly signed the grant of rights, the breach of contract, the breach of fiduciary duty. Those definitely all go out the door. You can no longer claim that because you're signing a new agreement with clear eyes, bright hearts in 2024, 2025.
Yeah.
There is some question still about the validity of the grant of rights. You could still make that argument in 2027 or 2028 as it's currently written. But the one thing that happens in litigation is when you point out the deficiencies of some of these agreements, typically they go back and correct those deficiencies. So yes, to your point, if you settle now in exchange for the benefits you're getting, you are basically conceding or agreeing to the reality that the grant of rights is valid and the grant of rights will hold you through 2030. But again, the Big 12 grant of rights was never challenged, and they simply bought out the agreement for 2 years or for 1 year. So that's why I still say there's a huge value in that we're not giving up a whole lot by staying from 2026 instead to 2028, and we keep $200 million in our pocket. That's a fair trade any day.
So is this something, people, I guess, both sides are kind of like AG Moody did, right? Like both sides claim victory over,
Hmm.
something either way, and both sides are going to claim victory in this.
Of course.
Can you read into this, and were Florida State and Clemson like scared of losing this? Is the ACC scared? Like, what's the motivator here, you think?
I've been going back and forth with a couple people on Facebook, and again, this is a reminder: it's hard to change people's minds on Twitter or social
Yeah.
media under any sort of circumstances. In any type of litigation, the plaintiff is the one that submits the demand. The plaintiff is the one that says, "Okay, I am suing you. If you want me to stop suing you, this is what I need." So first, you have to presume that the ESPN article is valid and legitimate. And let me tell you, as an attorney with dozens and dozens of newsworthy cases, the news reports are never 100% correct. You don't know what's wrong. Every news report is wrong for different reasons, but the news report is never 100% correct. Number two, so what if this was a proposal from Florida State or Clemson? Because the ACC could have been sitting there going, please, please, please give us something, anything. Remember, that's what happened with the AG Moody case. Please give us any compromise, give us anything so that we can save victory and save face. So I don't think you're dealing with a situation where Florida State is capitulating or Florida State is giving up or Clemson is giving up. And in fact, one report from one poster is that this is exactly what Clemson has wanted all along. Clemson never truly wanted to leave. They just wanted to, get the ACC to take this more seriously, get a little bit more money in their pocket, perhaps rehabilitate the conference in the eyes of the public. So, no, the fact that the proposal originated from the plaintiffs is not in and of itself indicative of Florida State capitulating or Clemson capitulating. Again, what did we want? More money and to be out of the grant of rights before 2036. Guess what we're getting? If this goes through, we're getting more money and we're out of the grant of rights before 2036.
I certainly have biases, and you do too. There's a signed, Bobby football back there and a signed team issued cleats back there. And so I have some biases. But to me, if the grant of rights was as rock solid and as bulletproof as it was claimed to be at one point, there is no chance the ACC would agree to any of this. Like if it was now the same argument can be used for Florida State. Oh, if you knew you got out, you knew you had I understand that. But to me, with the biases admitted, it feels more like the ACC is giving here than because again, this is what originally Florida State wanted. And maybe that's a good follow-up. Is it better for Florida State right now? Legal fees aside, I'll follow up on that in a minute. Is it better for Florida State now than even maybe what they were asking for, 2 Februarys ago? Like, is the pie sweeter now today than it would have been back then if the ACC would have caved then?
Yeah, because the grant of rights back then was through 2036. So that's indicative right there of the weakness that has been shown in the grant of rights. If there had been unequal revenue sharing, Florida State would have accepted that unequal revenue sharing, but would have been bound to the ACC through 2036. So now you lop 6 years off of that agreement. That's what this is all about. That's what this has always been about. The consolidation of all the conferences to the P2 and Florida State knowing they need to make their way into the P2. The money is secondary. The time is what is valuable and what is most important.
People, as an attorney, I'll straight up ask this. People, ask like, well, you've wasted, so much. Both sides have wasted so much money in legal fees. I saw Clemson went over $1 million. They approved another $1 million. But as undefeated as billable hours are, right? Like people like to use that phrase. Mm-hmm. It's still from all three sides. It's still pretty drop in the bucket compared to the money that we're talking about here, right? Like, the Florida State is not, cutting off its nose despite its face, right? Like in these legal arguments, it's such a small. It'd be a lot to me or you maybe, but it's such a small amount of money in the grand scheme, right?
I'm rewatching Yellowstone, getting ready for the end of the season to be re-released on Peacock here shortly. And there's a great line in there about Dutton sending his son off to law school. The modern tool, the modern weapon is words. Words are swords. We don't fight in the streets, or shouldn't fight in the streets. We're a little bit more sophisticated. But words are now the new tool, especially in business, to get things done. And that's exactly what this litigation has allowed. The parties, Florida State said 2 years ago, we want unequal revenue sharing. The ACC said kick rocks. All right, so let's start the process of litigating. Now here we are, 13 months after litigation started, and we're negotiating, and we're talking about giving us an unequal revenue share and now cutting the grant of rights down. There's no way that you could say the litigation was a waste of time. There's no way that you could say that was wasted money, because it has forced the parties to reach a compromise. Whether this is it or there's something else down the road, I've always said this was going to be settled. This was not going to be litigated. So the act of litigating gets the parties to a reasonable negotiating point.
Yeah, and it's tough to imagine, but if Clemson spent about $1 million, I'd imagine that Florida State's spending less than $5 million on this case, right? Like, it's just such a small amount. I guess that's, eventually would be, unless it's through the boosters, eventually would just be public knowledge anyway, what the spend. Oh no, it's through the board of trustees. It eventually will be, such a small amount compared
It'll
to
be disclosed.
Yeah, hundreds of millions of dollars that we're talking about. All right, so is this, look at your 247 crystal ball here. Is this going to happen? What has to happen to make it happen? Who has to approve this? What's the timeline for this?
Yeah, as I understand it, there's really two parts to this. The first is 75% of the conference members would have to agree to any material media rights agreement. I think this clearly qualifies for a material media right agreement, because you're talking about adding some more money from ESPN. Again, the threshold there is 5% of the budget. The numbers that you're hoping are added to this are more than 5% of the annual budget. And the second part is the grant of rights. You're modifying the grant of rights to that end. I believe that you're going to need a unanimous approval from all current members that are willing to sign on to the new grant of rights. The question is, what happens if that is not a unanimous decision? Does that one member then get booted out of the conference? I don't think that that's something that the ACC wants. Does it not go into effect and it stays 2036? Well, then you don't have an agreement. So I think that part of the reason why that last phone call went all 6 hours is because there's an effort to try to gain unanimity among all of the parties. And if that's the case, and I think it is possible, then yeah, I think this has a practical likelihood of getting done. Again, the objection from the other members is we don't want to give up a portion of our share. And that was the obstacle to a resolution before the litigation. Well, ESPN now, for a number of reasons that we can get into if you want to extend this discussion further, ESPN sees value in adding more money to the pot, sees value in giving Clemson and Florida State a percentage of what they're asking for, and that means that the other members don't lose out on a portion of their revenue. I think it's highly likely that unless somebody gets spooked or unless some new information gets developed, I think it's highly likely that this is the basic framework for a solution of this case.
I may edit out that part about you saying that other teams wouldn't be giving up their money, just so that I can say that Miami's paying us to stay, so I can get some jokes off on social media.
It's your show. You edit as you wish.
No, I'll leave it. But I had to get the joke off here at least. So any kind of idea on a timeline on this? Like, is this like a post-football season thing? I mean, I know that presidents don't necessarily run their calendars on football season, but we do here. So what are your thoughts on a timeline for something like this?
You know, if this pans out to be the case, then I will run victory lap after victory lap. But I've said all along that this would need to happen before January 31st, before the ESPN option was exercised. It certainly could happen this week. I mean, there's nothing stopping them from reducing everything to writing and getting signatures filed. There is paperwork that's needed. Just because you have the framework of an agreement doesn't mean that you don't have all 17 presidents now on board. They've all got their lawyers. All of them have to review any documents. So it's going to take, I suspect, weeks, even if this is the deal, even if they have the agreement in principle already and they're just floating this as a trial balloon just to make sure that there's no real objections. And there's value in the public arena in intercepting this information, noodling it out, putting all their thoughts out on Twitter, because you do get a bunch of different perspectives, bunch of different ideas that maybe some of the lawyers hadn't thought about. So in that process, they're probably going to analyze and put into writing exactly how this is going to work. And then all of the parties have to approve it. I don't know if that takes place before Thanksgiving.
So, FSU fans have spent the better part of the last couple of years certainly wanting to get out of the ACC, and I think you bring up a pretty good outline for why this isn't necessarily a bad thing for FSU. But let's look at the opposite side. Any cons here in your mind? I'll bring this up and then kind of let you answer. Certainly, people would say, well, money wise, okay, if we can break even, then that's fine, or even make more. Like that's great. But man, we still have a problem being in this conference from a perception standpoint. Does a 13-0 Georgia with a hurt quarterback get left out of the playoff? Does a 13-0 Michigan? So I know that's not really the legal side of things, but the ACC just kind of being a hindrance to the football program. I mean, most of the other programs haven't really hurt from that a ton. But thoughts around that, just cons of this, or maybe play devil's advocate to everything we've said so far?
I don't see any immediate cons, but I have some speculative possibilities that would not go well. The first of which is we're off to a pretty bad start. This is not the 2024 record that we anticipated. We really thought that we were building off of an undefeated season, that we had a floor of 8 wins, 10 wins, and that the question was just how well were we going to do from there. To your point earlier, if we don't figure out a way to eke out more than 2 wins this year, if we don't put it together, and if we back that up with another rebuilding year next year because we were too stubborn to try to rebuild this year, and we lay another egg, well, now we're talking about wrapping up our time in the conference and looking more like a historical Miami or worse. We have the second to last run offense in the country today. That has to change. If we find ourselves in a situation where we are in these new doldrums and Mike can't figure it out in the next 2-3 seasons, then yeah, we've put ourselves in a position where the ACC contract is extending or is ending, and we are trying to get into another conference, but with 3 lackluster years of performance as opposed to building on our 13-0 season. So that's one con that I could see. The other problem is, if we did have a landing space, if we did have a handshake agreement, if there was a new conference for us, which is a big if, understood, and the second part of that is we were already a full member and weren't coming in as a 50% or 60% partner, then yeah, we're giving up some money on an immediate year-to-year basis. Now, again, we're already in it for 2024. Nothing we can do about that. We're already in it for 2025. Nothing we can do about that. So the question is 26 and 27. Could we have gotten 10 million more, 12 million more? Possibly. But those are 2 big ifs. I don't know. I'm not convinced. I'd like to think our leadership has a landing place already, but I haven't seen anything definitive, and I'm not convinced that 100% guarantee we did, and 100% guarantee that was at the full membership value. So the cons are, like I say, speculative. I think when it comes to litigation, when it comes to settlement, take the guarantee, take the known commodity, and this settlement would reflect an excellent compromise.
I assume, Doug, once anything's agreed upon, then it's just very quick motions to, withdraw lawsuits, dismiss, and kind of move on from the legal stuff. I assume none of that continues to go on. But outside of that, anything else big picture that we should look at or talk about with this?
Yeah, the process of wrapping up litigation is very straightforward. It's informally as simple as calling the judge's office and saying, "Hey, we have a deal. Don't schedule us for any more hearings. We're all done." Practically speaking, yes, you do need to file motions to dismiss with prejudice. None of that typically happens until that the papers have been signed and any special conditions have been fulfilled. So whether that's ESPN depositing money in a trust account or something along those lines. But yeah, effectively, you would be able to call the judge and say, hey, any pending hearings, we're just going to go ahead and cancel. All of the efforts and emphasis at that point is on getting the paperwork drafted, approved, and then filed as part of a motion to dismiss.
Do you think this is a result I guess I got one more, a result of that mediation, or was this all kind of well in the works before the court ordered stuff?
No, I think it absolutely could have been part of that conversation. Again, the court ordered mediation. The purpose of that is to get the parties to sit down and at least contemplate, at least imagine yourself in a position where you're no longer litigating the case, and then just deciding, okay, what would it take to get to this point? The mediator has a very important role in doing that, but it starts with, can you see yourself in a situation where you're no longer litigating this case? Can you see yourself in a situation where you're satisfied with a solution? Once we have the visualization that you're not just a rabid dog fighting, or reacting, how do we get to that? What do we need to do then to reach such a compromise? So, but it does start with visualizing we're done, and the court ordered mediation is a very important part of that.
Doug, anything else big picture on your mind, or if not, tell the folks about Rohan Law, or maybe just do both.
Yeah. No, I'm excited. Like I said, this is very interesting. This is something that certainly it's not nothing is what we'll call it. I don't know what it is yet, but it certainly is not nothing. So I'm glad to see the parties are considering resolving this case, and then it's in a manner that is as favorable as I could have hoped for Florida State. Of course, getting out and not paying anything is the best case scenario, but that was never a realistic possibility. But yeah, Rohan Law in Atlanta, Georgia. We'd love talking to our friends and Nole fans and others who are perhaps in the Atlanta area. We've got a lot of new Clemson followers now, as well as a result of this litigation. So if you've been hurt at work or arrested for any reason, any types of charges, those are the two primary areas of practice that we handle here in Atlanta, Georgia.
Man, we appreciate you. Ready for this to be wrapped up and some kind of closure, whether it's what Florida State fans want or not, or if their minds have changed. I don't know, but I do appreciate you breaking it down. We're going to have to find some other kind of segment to do pretty regularly. Maybe it's baseball in the spring, because we've enjoyed having you on for sure. So we're not getting rid of you just yet, but when this wraps up, we'll have to find something else to do.
Sounds like a plan. Maybe I'll become an expert in contracts for conference realignment or something like that.
Good stuff. We appreciate it, Doug. Have a good one, buddy.
Take care.